Greetings, 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 greetings. It is I, your king, King Clifford Jefferson, ascendant from the house of Plantagen under King Godfrey the Fifth Caliban Jew. I am the reincarnation of King Edward the Peaceful, which you know as Jesus Christ. I'm here with my Queen Countess Godwinson from the house of Godwinson, as well as with my other members of the King's Bench, Archbishop Belmont from the house of Belmont, C.A. Murphy from the house of Murphy, Brother Esquire from the house of Esquire, Brother Burgess. We also have our other members who are here today trying to get an understanding on what it is that we are here and called to do. We'll get started. I'll have a couple words from the Queen, as well as Archbishop, as well as the CA and Brother Burgess. Then we'll move on to this marvelous lesson. The issue today in regards to today's lesson for the viewers is the history concerning the history of the registry of the birth certificate. We have participation by all members of the bench. Please take your notes. Those who have their pens and papers. This information is to be reflected upon the present information that had been posted on the present podcasters. So those who are able to view the present podcasters, when you review this prior content, you will be able to have a better understanding and a broader perspective of how to reflect it in this present day. So with that, I digress. I'll have the Queen say a couple of words.
Greetings, everyone. I hope at the sound of my voice that everyone is well. I like how the King said briefly that we are the peacekeepers. We are in a dire state here where everybody's suffering from what I would call delirium. Anytime you have a 6-year-old labeled at shooting his school teacher, a 6-year-old being labeled as a suspect, it just brings you to look at things and try to re-examine what exactly is going on in the state that we're living in today. But they say that the king is no longer here, or what is called a interregnum. But I'm here to tell you that the king is here. And, you know, we need to make these listeners or viewers look at things in a different light, I should say, and adhere to these lessons and get things back in order as far as your house is concerned. Like I said, we have mothers and fathers out there who's not in their right capacity, and they're led astray by the things that's going on in the world today. And I just pray that, you know, these lessons will bring calm to a lot of situations that's going on in the world today. And with that, I digress.
Well said, Queen. I like that analogy, light. You know, we got the true light, we got the false light. You know, without light, you can't see. And light gives you the ability to be able to observe. You know, so this light that we give you gives you the ability to be able to observe what's been hidden in the darkness. So well said, Queen. Mm-hmm. Archbishop Belmont from the house of Belmont.
Greetings, everyone. Apologize, I'm utilizing a new computer, so bear with me with the video. Welcome everyone to our service today. Today is January 8th, 2972 of the Berber calendar, which is equivalent to your now 2023 Gregorian calendar, which many people who don't know, if this is the first time you listen to our podcast, you know the Berber New Year, which is our King's birthday, is coming up this week. And we'll have the opportunity to be able to once again come together as brothers and sisters within the Kingdom of England, Empire of Albion, to celebrate ongoing celebration with bringing in the new year, for us to be able to start correcting the things that we know that needs to be corrected within our house. According to what Queen Godwin had just told us, you know, many of the brothers and sisters today are suffering what we call delirium or delusions. And the issue was going on with this goes all the way back to the 1774 Madhouse Act, which we had spoke about before. And like they say, there's nothing new underneath the sun. So things are just repeating themselves. And as us being those heirs and descendants who have been, classified underneath these fictitious terms that actually have ramifications to them, is our duty that we actually correct the record, and we won't be able to correct the record without having the proper studious teachings that the king is bringing and presenting to us, especially when it concerns the birth certificate. So please pay attention, make sure you got everything you need prepared, so therefore you can start bringing yourself home within the kingdom of God. I digress.
Well said, well said. We also have Officer Countess Allen. Greetings, Countess Allen. Good to have you here today.
She may just be listening in today, King.
Okay. All right. Esquire C.A. Murphy from the House of Murphy. Greetings, Noble.
Greetings, King. Greetings, Queen. Greetings, Council. Greetings, Archbishop, Esquire, King's Bench. Peace and love. I trust all is well at the sound of my voice. I just wanted to bring in the spirit of our ancestors, saints, and martyrs who bestowed this information, who had left this path of information for us to follow, so diligently picked up on. This information has always been here, but not everybody has the King's consciousness in order to observe, and delineate. So with that being said, I'd just like to bring in the spirit of our ancestors, King Alfred the Great, the author of the Anglo-Saxon Chronicles, who sought a united England amongst the Jutes, Angles, Saxons, and all of our heirs and ancestors. I'd like to bring upon the spirit of King Edward the Peaceful, known as Edward the Peaceable, John, the Magna Carta, all the way down to our King Clifford Jefferson. And it's just so important that we get these lessons in place on earth that you can go to get these lessons about your heritage, about the complexion, the brown skin Anglo-Saxon Berbers who were here in the American colony since time immemorial on into 1776 until now, 2972. That's of the Gregorian calendar up until now, 2972 of the Berber calendar, 2023 of the Gregorian calendar. We are here. We've never left. And it's important that as heirs, we make it clear to all belligerent trustees, fiduciaries in the place of successorship over our vast estate, that they're aware that we are aware that they are handling our estate erroneously and abridging the rights of our sisters, kith and kin, who are also heirs to this vast estate called the Kingdom of England, Empire of Albion. So I just like to call upon our ancestor spirits to be with us here today. It's very rare that get an opportunity to speak, but with that, I'd like to use that to bring in the ancestors, the saints and the martyrs who guide our tongues, guide our thoughts, and to guide our studious application of the knowledge that we receive here in this quorum. So with that, I digress. I love you all at the sound of my voice, and I'm looking forward to this marvelous lesson. And we also look forward to our celebration on June 14th of our new calendar to celebrate our King's solar return. So peace and love. I digress, and let's get started with this marvelous lesson. I yield.
Thank you, CA. That's January 14th.
Excuse me.
January 14th. You said June. It's all good.
Them J's.
January 14th. All right, it's all good, Noble. And last but not least, we have our Noble from the Brother House of Burgers. We know Burgers means freedman. So I give a lot of honor for him stepping up to the plate and understanding that how important it is to be a part of this actual quorum. Because it was through the quorum of the freedmen, or assumed to be freedmen, that the so-called founding fathers took their lead from. So without ado, I give honor to Brother Burgers from the House of Burgers. Greetings, Noble One.
Greetings, family. Forgive me, I'm
Great.
a little jittery. I still get excited about this. Every
Come on, man.
I
Still
got-
get excited. Come on, man.
You know, King, watch this. Every man and woman is ahead of their own spaceship. Now, and you must be able to use your senses or your own faculties to download what you need to connect yourself to time immemorial, to do what it is that you know you need to do. No one really can tell you what to do in regards to your hereditament. That's how you're going to get recognized by the king, to make yourself back to your prospective houses. So I I think I'll leave it short and sweet, just like that.
Thank you, thank you, thank you, thank you. And I'm pretty sure all those at the sound of our voices feels the same. But once again, for all those who will be viewing this, key point with Brother Esquire is spaceship. Because if you're not using the space that you're given, you're just taking up space. That's all you're doing, taking up space. Space ship is a ship that moves through space. Ship means to move. So if you just stagnated, then you're just taking up space. So we're putting you in the ability to be able to move in space and time without actually leaving your body through what we call autobiological memory. So follow us through what we call autobiological memory, which is what we call daydream. Daydream with us for a little bit and see for yourself with your mental faculty that your physical faculties cannot comprehend until the mental understands what it was told to comprehend to tell the physical. So with that, let's get started. On behalf of each and every one of you here today at the English Magna Church, we greet you, we love you, we honor you, and we thank you for being and showing your allegiance to the English Magna Church under the authority of the Crown. And with that, let's get started. All right. Everyone at the sound of my voice, give me a second. Let's share. All right, here we go. Everybody remember this article, right? Everybody remember this article?
Mm-hmm.
History of
That's the
Registry.
little note.
That's the homework. We're just going to read a little bit and just discuss it as we go along. We give each and everybody a couple minutes, 2 minutes to say something about the content. And then we can move forward with the justification based off the interpretation of the content and be able to justify why we're here today in regards to the content, which put us in this predicament based off those who created the content. But it all goes back to what we call letter pack. Yes, letter pack. Letter pack means an open letter to the public. Open letter to the public is actually a letter declaring something or proclaiming something on behalf of oneself, on behalf of others. Everybody keep that in their mind state, okay? Fortunately, due to the sisterhood today, our sisters are under the weather. So we're going to start with those who were able to make it today. Countess Middleton, we greet you for being here, our elder. And what better person to have read as an elder? Because it's the elders who we look to our future. And our elder, Sister Middleton, looks to the stars. And stars are a replication of us expressing ourselves to our ancestors who has transferred to a rim that we know not of, based off our comprehension. This is why we talked about time immemorial. Time immemorial, a time where memory can't go back to. All right, so without further ado, Countess Middleton, do you mind reading for the visitors?
Of course, King. I'm just waiting on the page to be shown.
Let me check. Here we go.
Okay. The history of registries. The existence of a birth certificate is prima facie evidence of the existence of a title. The existence of birth certificates, the statutes that created them, from settlement certificates to admiralty-based birth certificates, is overwhelming and irrefutable evidence of organized and systemic slavery, in complete contradiction to all laws claiming the abolition of slavery and servitude. as settlement certificates and later birth certificates are evidence of a receipt of a title being released.
Okay, let's talk about that. The existence of an instrument called a birth certificate and the statute that created these instruments called birth certificate denotes to a title, denotes to something of title. And we know a title means nothing more than an interest in something. For those who created it, those who hold it, and for those who it pertains to. In this case, it's talking about a certificate, and a certificate is nothing more than a legal instrument. A legal instrument concerning one's birth and the territory. Okay, let's be a little further.
Settlement birth certificate. A settlement certificate, known as a birth certificate, is the formation of central records and registers in 1836. Number one is an official document possessing multiple legal functions and states under the central presumption that those against whom such instruments are issued are a form of property and bonded servant or slave to Western Roman and private banking interests, regardless of status or family or history. Two, under statutes and policies promulgated from Westminster and other bodies, a birth certificate fulfills multiple and distinct functions and states, depending upon its recognition and activity at hand, including, but not limited to, 1, certificate of title to cestui use of person, being recognition that the state claims ownership by virtue of the certificate itself and all the information contained on it, therefore proving a cestui trust in place, and that the man or woman or newborn to whom the certificate applies only has beneficial use of the name.
Okay. All right. Now, anybody like to take a shot at interpreting what it means in regards to the purpose of the birth certificate, in regards to those who created the birth certificate, in regards to the rights protected under the birth certificate, which we're subject to the conditions today? Anybody want to take a shot at that? Countess Middleton, you can go first. Just sum up for the people. What's your interpretation from what you read thus far?
The birth certificate is being used as an instrument to keep people as a form of property and bonded, but its original intent was to show a title. So it had a much more positive or progressive status.
Mm-hmm. You good?
Yes.
Okay, all right. Well said. Brother Burgess from the House of Burgess. We have viewers out there that want to hear you articulate what it is that we're reading and trying to interpret for them to understand, since they can't interpret it.
Well, what I get from it, I'm looking at my birth certificate now, and I understand the statutes of its origins is what actually is giving them the authority and is tying me into these privileges and benefits that I use from the state which created the certificate. My name is given, so I can understand I have no legal or no trusteeship in the name itself. I can only reap the benefit from which the trust gives me. And when I act outside of that, that's a breach on my end of not conducting myself properly within the body of politics that we apply.
Well said. Well said. Biblically broken down, biblically articulated, as well as making it able for those who doesn't understand such terminology to make it be able to be applicable. So well said. Brother Means from the House of Means.
Yes, sir. And reading the creation of the birth certificate, from what I see and understand, is that they usurped authority of our likeness and creating us into a form of slavery for commerce use and purposes is the whole purpose of what I took from the birth certificate. Being a settlement certificate is saying that they made a settlement of the whole landmass being a plantation, and those that inhabited it were being created as a legal fiction for the purposes of their conducting business here throughout their whole corporation and the subsidiaries put together. And then the Seste QV, the Seste QV is also an entrapment. That our parents on paper created and give life to them of the use of the legal fiction being in the likeness of our name. Now it says that we have no rights to that, which we do, because without our parents' signature, the creation is not life, is not given, there's no purpose in it, it has no standing. Now our status was taken from us, being nationals of an English nation by birth, and then the entrapment of the official signatures from our parents, as I was saying. But now chapter 11, 18, 19, and chapter 2 in there, stating that if you were alive, if you can prove that you're and come into a nutshell, saying that we in the United States have created a documentation that you sign yourself over to us, and we have control of all your estates and your likeness and your purposes in life, that we can tell you what to do, when to do it, how to do it, under a false presumption.
I like that. False presumption. That's what the courts go by. Presumption at law. And the presumption is what you can prove. You have a basic fact and you have a presumptive fact. A presumptive fact is saying that you didn't do nothing. You ain't got no evidence to prove it, but you just saying, hey, as either you did it or you didn't do it. I didn't do it. A basic fact is proving that the presumptive is either false or true. So what's that, brother Means from the House of Means? Brother Scott from the House of Scott, what is your intake on what Council Middleton just read?
Well, just to camelback over everyone else, we all know that the birth certificate sometimes is called a legal fiction, or what they call a straw man. From the research that myself and Brother Burgess did, there's a parallel that runs with the Admiralty law. It seems to be a type of manifest. It seems to be a designation or a claim of property based on the people that issued that certificate. So again, we were infants when our parents did sign us into this, but it was out of duress and coercion because of the way the system is set up. The parents did it out of pure ignorance. So based on this sesquique, this trust, they say we only have beneficial use, and that's very limited use, and it's only for the name per the research that we looked at earlier, King. I digress.
Well said, Brother Scott.
Man. Okay, I'm really inspired to see what Brother Burgess say. Brother Burgess, what is your intake?
I mean, I thought I went, but I go for
I got you.
Did he go? Did he go already?
I can further expound if you
Nah, you
Brother
had your
Burgess went.
introduction. He went?
You want
Yeah, Brother Burgess.
I'm gonna let you slide.
me to go again. I'll go again.
Interest.
Nah, you didn't win already. We're gonna let you slide. You should have said in the first call. C.A. Murphy from the House of Murphy. It's all love, though. Greetings, C.A. What's your intake, Noble?
Peace and love. All right, here we go. Certificate, birth certificate, settlement certificate. Yes.
Let's try to keep it limited for the sake of the panel.
Yeah, you know, King, I got a mouth and a brain full of it.
Yes.
A settlement certificate is certificate in lieu of title We know only real title is entail, and a certificate is just that, a certificate, a receipt showing an interest in something, not ownership. So birth certificate is a certificate in lieu of title. It is an adhesion contract between your parents listed as agents or employees of the said state in registering their property. You as children have no say in your registration in this birth certificate, but I'm about to drop a jewel on you. Pay attention. Your registered date, it differs from your birth date. If you look at all of your birth certificates, you have two dates. You have the date that you were born and the date that you were registered to the estate. It's all listed on the same certificate. That shows that there are two different dates. Birth as being brought onto the land from water, admiralty law, shows your allegiance to the land. So if you have a birth certificate, you are in league with the state. And not only are you in league or subject to the state, you are registered by that registration number, which sits alongside your birth date, which are two different dates on the same certificate. I will leave you with that because I could say more, but that is the jewel right there. Peace and love. I digress.
Well said. Well said. Now, what I love about a breakdown before I let the Countess, the Queen go, we see that all these are qualified by numbers from monarchs. This is King William. So not only is the king there, the council's there. And this is somebody else's breakdown of the history of the registry back to the time of the kings. Because before you had hospitals, you were registered with the church. And the church governed those who live in what we call the communities, made up of the settlements. So you got the settlements, i.e. those who incorporated, i.e. those who colonized, and those who were originally here. And we're not talking about those who colonized, we're talking about those who were here. And we didn't need a birth certificate because our was already declared by our surname. We're gonna get into this in further review. Queen?
There are no reasonings. I think that when they created this birth certificate, they knew exactly what they were doing. And to me, it was just created to bring in revenue. We all know what the true meaning of letter patent means. But in their eyes, a letter patent is actually a written order granting an office the rights over a person or corporation.
Mm-hmm.
So to me, this is why they created the settlement or birth certificate, was to make these individuals actual wards of the state, like I said, and to bring in revenue.
Well said, Count. Well said. Beautifully seeing the language coming from those on the panels, which are responsible for this language, for those who don't know this language. So well said, Quinn. Archbishop Bell from the House of Belmont.
Once
What's your
again,
intake, over?
Beautifully stated, everyone, your responses, and you're absolutely right. A certificate is exactly what it is. It's a receipt. And in this case, based off of the
Archbishop, before you go, if those who want to make a remark in regard to the podcast, you have to show your screen. You have to show your screen because people need to know who's talking. If you want to stay silent and just review it, that's fine too, but you're not allowed to participate and articulating what it is because people need to see. So those who want to be able to give or articulate what it is that we're discussing today, you have to be shown on the screen. Okay, go ahead, Archbishop.
All right. Yeah. So like the birth certificate, exactly what it is. It's a receipt, but it never really says a receipt of what, of what's been received. You know, like for instance, we know that those who are actually doing the shipping and receiving were merchants. So they had to see you as a so-called form of merchandise, i.e. chattel property. So when you hear or think about the birth certificate, it's really just saying what's being born is some form of good that's actually came from a different place, you know, from place, what we call place either A, B to C. So that's the only thing it is being transporting of goods. So now that we understand what the birth of it mean in settling, what does it normally do when you think of something settling? Sitting still. So what they're doing, they're producing chattel property that's going to be sitting still somewhere, and this is the receipt of it. It is not telling you if it's a human being either. So that's the kicker about this. And then once again, like what CA was saying, that about the beneficial use. Remember, if they're making you just a beneficiary, it doesn't necessarily mean that it's actually yours. It's just saying you're getting a benefit out of it. What you're benefiting is depends on who created it. And in this case, merchants created it. So you're at the will of those who, once again, is shipping you back and forth via the Transportation Act. I digress.
Well said. Well said. Who spoke thus far? Anyone else would like to speak? I don't see anybody else screen lit up. Let me know if you would like to. Who is that?
This is Scott, sir. May I ask a question?
Yes, you may.
Can you hear me? Can you hear me now, King?
Yes, I can.
I think Queen
Go ahead,
may
what's your
be
question?
onto something because Brother Burgess and I noticed that everyone's birth certificate is on bond paper. So we were curious as to why would he do that?
Linen paper, that's right, linen bond paper.
Then repeat that again.
The birth certificates are generally and usually on bond paper. So we have to assume that's some type of negotiable instrument. Is it traded on the stock market? What is the purpose of these birth certificates being on bond paper?
Okay, because we know when a bond has to deal with attainment. That's why they call bills of attainers. When a person has a bill of attainder, it's already assumed that that individual is in the court's jurisdiction. And you're already in the court's jurisdiction because the judge is the one who decides on the matters concerning orphans. Orphan is called probate court. Orphan court is called probate court that deals with the estate of minors. So as we already concluded here, the birth certificate is an instrument that denotes to an orphan that became a ward of the state by way of being reclassified and having a legal personality bestowed upon it.
Point of
So
interest.
therefore, when they come in contact with you by way of like a stop and arrest, they already have the ability to have what they call a bill of attainder.
Yes.
Because you're already in the jurisdiction of the court. That's why the only way that you can convert that is do what we call a writ of habeas corpus, bring forth the body. The only person who can do that is the king's court. A king's court is called a prerogative court. A prerogative court deals with the matters that deals with what we call common pleas. Common pleas deal with matters concerning individuals on the king's land because the king's not there. So you brought before what they call the privy council, the governor and the council. If the governor and the council on appeal, because it was a last court of resort, because most administration that you see now are nothing more than administrative agencies. They're not judicially created by the legislature. They were created by the act of the executive branch, which is a violation of the legislative branch because the executive branch is supposed to be following what the legislation say, not based off your amending of the legislation based off an executive act. So that result of the birth certificate, you're already subject to what they call bills. When you receive a bill, what it means, you owe, right? That's something to note to a debtor. When you're a debtor, you can either be debtor to the king, which falls in what we call the court of exchequer.
Mm-hmm.
The court of exchequer is also a part of the king's bench. The court of exchequer split with the courts of common pleas because the king ain't there. So they're not dealing with the debts that belongs to the king, nor the king's bench, because everywhere the kings go, the king's bench go. Everybody follow? To answer your question.
Yes, sir.
Okay. All right, Brother Hobbs.
Thank you for allowing me to speak in your house to the members. In the settlement certificate, we're talking about blood right. freedom from attainder, inheritable blood. So when they legally strip us from our rights, they're doing so with the Bill of Attainder. And how we claim or receive those rights back is by claiming our inheritable blood. Part of claiming that inheritable blood is claiming the hereditaments or rights to that title. And I yield, King. Thank you for allowing.
Beautifully said. This is the first time this brother spoke on the panel, and
Well
everything he said was sound. Beautifully said, Brother Hobbs, the Noble House of Hobbs. Do we have any more partakers?
Shall I speak? Offer any more?
I want to give everybody. I know those who are under the weather, they are able to speak because of their sick. So, Lady Harris, you are able to speak?
No, she says she's under the weather still as well.
Right. What about Countess out?
I think she's going to be just listening in as well too. Because remember, I told you earlier regarding her situation.
Okay.
But we do have
So
Countess
let's
Walker.
move.
I don't think she heard that part yet.
Countess Walker.
Let's see.
Countess Walker. Is she there?
She probably still at work right now.
Okay, it's all good. All right. So, Countess Middleton, you continue on.
Yeah.
Well said, everybody thus far.
Yes. So 2, certificate of title of property being the recognition of the fact of a birth certificate being a certificate, that the name is property and therefore the man or woman or newborn is now treated as property and no longer as a living man or woman, subject to the rule of law, astrum uris divin canonum, in original Latin with the word canon. 3, certificate of deposit and bailment or custody, being the recognition through the terms used to describe the father and mother that a transaction has taken place and the newborn is no longer owned by the parents, but is in the custody of the state, any higher estate under Roman or Western law recognized as possessing political and topographical territorial boundaries and sovereign jurisdiction under parliamentary and government apparatus, with the newborn now a thing subject to jurisdiction of the courts having been registered or enrolled. Certificate of second-class citizenship under sestaque use of person, being that the certificate recognizes a newborn not being a citizen, but a second-class citizen not having fully control over the body or mind or name or spirit, all claimed and put forward by others above as public officials. Certificate of bondage as slave, being the certificate as recognition of a man or woman or newborn as a member of the poor, the paupers, the infants, the idiots, and lunatics, the horned cattle, the beasts, the creatures, the humans, the dispossessed, the insolvent debtors and criminals, and enemies of those who have created holy, mythical, and religious and legal texts, the debt slaves. The term birth is a synonym of the Admiralty term berth, B-E-R-T-H, from the late early 1600s, meaning a fixed address or position on a ship or room in which the ship's company resides, or a space for a vessel to moor or settle. In turn,
Spaceship, y'all. Spaceship. All you doing is filling in space. You're on a ship that you can't see. There was never no boat. That boat story cannot qualify all the small people who have these English names. They can speak for those who have African names, but not for those who have English names. That's a whole different category, y'all. Does that make sense?
Yes.
Continue on, Countess Middleton.
In terms of the history of birth certificates, settlement certificates can place free people as slaves, wards, infants, cattle, poor, and commodities for a monetary debt system. It is needed to be noted here that settlement.
I'm sorry, 1 second. Go ahead.
It is needed to be noted here that settlement in reference to the full process of administration, distribution, and closing of the entire estate.
I'm sorry, Countess. I don't know what my screen doing. Where was we at? Okay, go ahead.
It is needed to be noted here that settlement in reference to this instrument, the full process of administration, distribution, and closing of the entire estate, and the word instrument noted here in reference to settlement and birth certificates, with the meaning from Latin with the present document, unless otherwise specified, in which case it shall mean a document possessing certain requisite legal form, such as a deed, covenant, charter, letters patent, indenture, contract, writ, or warrant. In this case, for the definition of letters patent from Latin, from 14th century Latin, lettere patentes, meaning literally an open official letter.
This is the very first video that I did. And we didn't start talking about letter patents to the last video. We just went into that topic in the last video that we posted. And I was already talking about it from the first video. And everything I said in the first video is on point. It's on point. Continue to read, Countess.
See, I think CA had.
CA, go ahead, CA.
Point of interest, what she just read was that birth certificate is a fixed address. I just wanted to reiterate, camelback on what our Countess Middleton read, that birth certificate is listed as a fixed address, and all of you viewers are sitting on a fixed address. I yield.
And I like that because that comes through what we call land use regulations, through what we call land marketing, or what they call land use, land marketing, or land use regulations. This is all under what we call eminent domain or police powers. The use of a land is called a land grant. I'm gonna say it again. The use of a land was called land grant. And the first land grants that were given out goes back to the Virginia Company, called the East Indian Company, which was based off head right systems. Head right means slavery.
Mm-hmm.
Do y'all hear me? The first land grants given in North America by the House of Stores, i.e. King James, a pretender of the English crown, was based off head right system, based off history going back into the slave trade or the North Atlantic slave trade, called the Middle Passage, which is right here in North Perth Amboy, under what we call letter patent by way of an open letter. Why? Because these come from minors. The origin of letter patent, in order for you to have a land patent, you must have a letter patent. A land grant is not a letter patent because a letter patent is fixed. It's fixed in law. A land grant can be challenged at any time. I'm going to show you Magna Carta, Article 26. Continue to read, Countess.
From
While we're
12.
talking about letter patents, y'all.
Hold on,
We're talking about letter patents.
Point of interest, and like you stated, a letters patent is a public letter, which means that the birth certificate is a public document. So that how it automatically pulls you into the public ab initio because of that document itself, which is a letter patent.
Mm-hmm. Well said. Continue to read, Countess. You know, you get tired, we can give you a win.
No, I'm good. A
Okay.
letter, a letter's patent is similar in respect to a charter in being used for official grants, titles, laws, right, or monopoly, and also in respect of honoring traditional form, including the incipit, the datum, and the seal. However, letter patents may be on several pieces of paper and not vellum or animal skin, may use black ink instead of red, and a printed seal instead of a bulla.
Okay, so letter patent is a charter, official grant, title, law, right, monopoly, title, status. It can also grant coats of arms. It can also grant authority to create a municipality. That's called a monopoly. A monopoly is based off land grants, which is based off land use regulations through land marketing. When you roll down on the land, they call a street an avenue, street, boulevard. That's called land use regulations. And it imposes a burden on the religious society because that makes you or separates you from the jurisdiction of society based off the land use regulation, which contradicts the legislation because the legislation derived from common law. And there's only one common law, that's the common law of the people, and that's the law of England, governing the land. And in order for you to have a land, you must have a letter patent. And the only way, and a letter patent qualifies a land patent, and that was given to what we call the proprietors. Continue to read till we come to our closing, start right here.
In 15,
Hold on,
Okay.
1 second. Let me find it. Start. Start here. Venetian Piscian Model Conference.
Venetian Peace and Model of Commerce. The act also introduced a new levy collected by parishes, was called the poor rates, now called council taxes, against wealthy property owners for their rent of use of the poor as slaves. This is the financial origin of annuities 100 years later. Under Charles II of England, the concept of settlements as plantations of working poor controlled by the Church of England was further refined in 1662. Number 12.
Stop right there.
Okay.
Now, for all those things, oh, that's the article somebody wrote.
Okay.
Okay. Let's go to the actual document. So this is an actual document, y'all, that you can go to. That's our reference. Somebody else is speaking about a legal document from a king. All that's right up in here. We're not gonna go through that because we're referring to birth certificates. So let's go back to where we was. Continue to read.
Including for the first time the issuance of settlement certificates equivalent to a birth certificate, passport, and social security rolled into one document. A child's birthplace was its place of settlement, unless its mother had a settlement certificate from some other parish stating that the unborn child was included on the certificate. However, from the age of seven upward, the child could have been apprenticed and therefore sold into servitude for some rent paid back to the church as poor taxes. The act also made it easier for the clearing of common houses of the poor, and for the first time made the definition of poor the value of tenancy being a taxable value of less than 10 pounds per year. The act also modified the age of emancipation from child slavery to adult slavery as the age of 16.
Right there. Okay, so we went all the way from Elizabeth I, Edward VI, Henry VIII, Henry VIII dissolved the monastery. The dissolution of the monastery was through what we call law reform, or the changing of the law. And we know the law deals with the legislator, and the legislator is created by those who created the law. And the origin of law creation goes back to Parliament, or what we call the parliamentary system, which is called the standing rule. Every Congress has a standing rule of how they are able to act. Under the United States law is Article 1, Section 5, which governs the authority that's given from the Senate and the General Assembly. The Senate is the House of Lords. We know under the Commonwealth, the House of Lords and the House of Lords and the King was dissolved through what we call the interregnum. So that left the interregnum in place, and I left the council, or what we call the Privy Council, which was the governor. That brings in what we call the courts of common pleas, because the courts of exchequer dealt with the king and whoever owed the king and the debtors. All right, now let's get out of this and go ahead. This is Thomas Jefferson. I mean, this is Edward Quentin Keesby. He's a district court judge. We're just going to briefly discuss this judge, because the district court judges, if we go back to Marbury versus Madison, let's go there first. They were letter patents. Since we discussed the letter patents. Now we're going to read the very verbiage that they said in the letter. We're going to read it right here in Wikipedia. Read the first paragraph, Countess Middleton.
Letters patent, literae patentes, are a type of legal instrument in the form of a published written order issued by a monarch, president, or other head of state, generally granting an office, right, monopoly, title, or status to a person or corporation. Letters patent can be used for the creation of corporations or government offices, or for granting city status or a coat of arms. Letters patent are issued for the appointment of representatives of the crown, such as governors and governors general of Commonwealth realms, as well as appointing a royal commission. In the United Kingdom, they are also issued for the creation of peers of the realm.
Okay, so now we just read, we're going to read from Edward Quentin Keesby, who is a district court judge who sat under 6 presidents, from Abraham Lincoln, under 6 presidents, this district court judge sat. Now we know under the Judiciary Act, which is called the Writ of Acts, the Writ Act was a law created by the Supreme Court under the Judiciary Act of 1789. This Judiciary Act was introduced by Richard Henry Lee and signed into law by George Washington, the first president. The second president, John Adams, initiated through letter patents 42 district court judges. And William Marbury, who commissioned these letter patents for these commissioned judges, were denied the letter patent as a result of them being invalid because it stretched the authority of Article 3 of the United States Constitution. What do I mean by this? The law in the United States Constitution only granted one Supreme Court, Article 3, Section 1. The district court judge, the Judiciary Act for the district court judges under William Marbury, who signed into law by John Adams, the second president, was created by an act of Congress. An act of Congress is an act created by statute, but it was contrary to the legislation intent of the Constitution, because the Constitution is the instrument that governs the 3 branches: the executive, legislative, and judicial. The legislative branch has the authority to create the laws. The executive branch executes the laws created by the legislative branch, and the judiciary branch upholds the laws that are executed by the executive branch on behalf of the legislative branch that created the law. If the executive branch exercised any law passed by a legislation that was created by the original legislation, it's arbitrarily administrative law. Everybody follow?
Wow.
And when they created the administrative law by the executive authority with the help of the legislator going rogue, that they created the judiciary to uphold those laws. That's why when you get in the case dealing with Marbury versus Madison, and the 42 district court judges created under the Judiciary Act, when James Madison, the Secretary of State, now remember, at Congress, the original Congress, these were members who created the quorum, which were a part of both houses. They were a part of the executive branch and the legislative branch. That's a contradiction to the separation of powers, ain't it?
Bicameral unicameral.
You can't have a separation of powers when a member of one branch is a part of the other branch.
Mm-hmm.
And the Supreme Court got put in the middle of it as a result of the executive branch not honoring another part of the executive branch, because John Adams was leaving the presidency and Thomas Jefferson was coming in on the presidency.
Mm-hmm.
And all the district court judges appointed by John Adams goes back to the Judiciary Act created by the president, George Washington, and was introduced into law by Richard Henry Lee, who created Lee's resolution to break away from the crown.
Yeah.
He the one who created Lee's resolution for the United States colony to break away from the crown. Once they did that based off of an executive act contrary to the legislation, then they created a judiciary branch called the Judiciary to keep those laws in place.
Exchequer, yeah.
They took out the exchequer branch because that was held under the king and created a court of what we call common pleas.
Mm-hmm.
All right, now, what makes this important? Okay, under the Judiciary Act of 1789, Section 13, Marbury and Madison case in 1801, Chief Justice Marshall decided not to grant a writ of mandamus. A writ of mandamus is a writ that's called a prerogative writ. And the origins of prerogative writ falls under writs given by the crown. Now, we just went into the letter patent. And letter patents are a type of legal instrument in the form of a published written order. A writ is what, y'all? An order. A writ, the original word of the word written is writ. W-R-I-T. Everybody say it, right? Written, the origin of written comes from writ, means an order issued by a monarch, because that's the origin of what the writ comes from. But then when the presidents created the judiciary and they didn't like each, because remember, even though they were presidents, they were at odds against each other because of that power, that seat they were sitting in. That executive power, that seat of executive power, which was invested by the legislature. They wouldn't have that invested power if it was not for the legislative branch. CA.
That is the point of where the term power corrupts and absolute power corrupts absolutely. Because if you give a gas station attendant a governorship over a country, that gas station attendant is going to be rogue. He's going to be trying to do all kinds of things. This is what you have here in today's time. You have people who are not fit to rule or not fit to govern in the seat of government. They don't have a coat of arms. They don't have a letters patent issued by a monarch. They have a corporate charter in lieu of a monarchical letter patent given. So this is where the court of exchequer, if you if you go to probate, in probate court, opposed to you're seeking remedy or you're seeking, these probate courts or these exchequer courts don't have a letter patent from a monarch. They have a corporate charter. Mm-hmm. So each one of these corporate charters only have a de facto administrative law to give you. They don't have a lawful remedy to offer you because they are not authorized to give such. I yield.
Well said. And that brings you into the next paragraph, because everything they do is based on what we call copyright. All they sales, everything dealing with the language they use in their administration had to be copyrighted, because that's called intellectual property. Intellectual property is called secrets of the trade, because these nations were based off commerce. So there's secrets of the trades that they stole from Great Britain under de facto monarchs that kept it in place. They just took out the authority of the monarch and gave it to a president. Now the presidents can issue letter patents to appoint judges, because judges are called justice of the peace. The word justice of the peace is the keeper of the peace, and the keeper of the peace is called the king's peace. That's the purpose of a letter patent, because it says letter patents can be used for creation of corporations or government offices, or for granting city status or a coat of arms. Letter patents are issued from the appointment of representatives of the crown. So if you're a representative of the crown, that means you're a part of the king's bench. If you're not a part of the representatives of the crown, that means you're a part of the government, which comes from the president, from the United States, which did not come in place because before you had a president, you had governors running the show. I'm going to show you in a second. Such governors, which were called royal governors of the Commonwealth, because when they took out the lords and the king, it was put under a Commonwealth, which is called an interregnum. And the United Kingdom, they are issued for creation of peers of the realm. So they created their own peers of the realm. This is why when the creation of the General Assembly, called the Privy Council, elected their members out of their communities to become the Senate as well. This gets into what we call the House of Burghers. The House of Burghers are called freemen of the counties. That's all it means. Our people are assuming to be free men, but you're not a free man because you're a subject of the crown. The only person that can be free men is the heirs of the crown, and that's us, burghers. That's why you have Brother Burgess is a true heir, because his coat of arms didn't come from letter patent. He was born with it. Everybody understand? Just like we were all born with ours.
Yes.
Nobody can issue, because that's violation of Article 168, paragraph 9. No title of the Nobility Act. They are not to be granted. Only by those who have the authority to grant it, which is a letter patent by the monarch. Read the next paragraph, Countess Middleton. Right.
A particular form of letter patent has evolved into the modern intellectual property patent, referred to as a utility patent or design patent in United States patent law, granting exclusive rights in an invention or design. In this case, it is essential that the written grant should be in the form of a public document, so other inventors can consult it both to avoid infringement while the patent remains in force, and to understand how to put it into practical use once the patent rights expire.
Stop. Okay. So we know there's a difference between a letter patent from the United States and a letter patent from England. Let's just see what they are. United Kingdom, read that.
In the United Kingdom and other Commonwealth realms, letter patent are royal proclamations granting an office, right, title, or status to a person, and sometimes in regards to corporations and cities. Letters patent take the form of an open letter from the monarch to a subject, although this is a legal fiction, and they are in fact a royal decree made under the royal prerogative and are treated as statute law. Letters patent do not require the consent of Parliament.
Okay, so Parliament does not need to consent to a letter patent. Why? Because it's a royal prerogative treated by way of statute. That's called the demise of the crown. The demise of the crown is the transfer of the sovereign power of the attributes of the prerogatives of the king. That's called writs. The king has allowed to issue writs, because the origin of the writ is an order. Now, once they took out the king and the House of Lords, now they start issuing orders of their own in the United States called letter patents. And read what that says.
The primary source of letters patent in the United States are intellectual property patents and land patents, though letters patent are issued for a variety of other purposes. They function dually as public records and personal certificates. In the United States, The forgery of letters patent granted by the president is a crime subject to fine, imprisonment up to 10 years, or both. Without letters patent, a person is unable to assume an appointed office, such as
Read that again. Read that part again.
without letters patent, a person is unable to assume an appointed office. Such an issue prompted the Marbury versus Madison suit, where William Marbury and 3 others petitioned the United States Supreme Court to order James Madison to deliver their letters for appointments made under the previous administration.
Okay. Everybody, all right. Letter patent issued by the United States General Land Office. What does the General Land Office have to do with a letter patent for the appointment of a judge? What? Thank you, Queen. All right. So as we can see, it just said under United States Code, Title 18, if a letter given by a judge unlawfully, then you can go to jail for 10 years. This case is implemented, this fact is implemented by Marbury versus Madison, who was the district court judge appointed by the second president of the United States based off the Judiciary Act introduced by Richard Henry Lee and signed in by the first president, George Washington. And Thomas Jefferson, with my surname, which he had my surname, disagreed with every appointment that was commissioned by James Madison and James Madison and George Washington based off the Judiciary Act. Because if the act was lawful, that means that why did William Chief Justice Marshall issue it? I'm gonna tell you why, because they didn't have the door.
The All Writs Act is a United States federal statute codified at 28 U.S.C. 1651, which authorizes the United States federal court to issue all writs necessary or appropriate in aid of their respective jurisdictions and agreeable to the usages and principles of law. The act in its original form was part of the Judiciary Act of 1689. The current form of the act was first passed in 1911, and the act has been amended several times since then, but it has not changed significantly in substance since 1789.
All right.
The text of the act is, the Supreme Court and all courts established by act of Congress may issue all writs necessary or appropriate in aid of their respective jurisdictions and agreeable to the usages and principles of law. An alternative writ or rule, nisi, may be issued by a justice or judge of a court which has jurisdiction.
Okay. So we're dealing with all this without Title 28 United States Code 1651. That goes back to the Judiciary Act of 1789. And the Judiciary Act of 1789, Section 13, the Supreme Court ruled that it was unconstitutional because the Supreme Court didn't have the authority to issue a writ of mandamus on behalf of a district court judge to compel the Secretary of State to do anything. So if you're saying you got the authority to issue a writ, what was Chief Justice Marshall's problem with this Writs Act that goes back to the Judiciary Act of 1789? Because he knew something that nobody else knew. Let's discuss what he knew that nobody else didn't know. Because Thomas Jefferson, Secretary of State, James Madison didn't issue a writ, and he was the Secretary of State for the now coming into inauguration, Thomas Jefferson. So let's read Thomas Jefferson's standing rule for Congress, pursuant to Article 1, Section 5. And this is a rule that the General Assembly, wasn't no Senate, because the Senate was just those directed from the General Assembly as members of the so-called community. However, it's us, that's us right now, revealing the acts committed by the General Assembly as those who became part of the colony who broke away from Great Britain, i.e. the founding fathers. All right, so let's reveal what Thomas Jefferson said in regards to the standing rule, because you got 3 types of standing rules that they go by today, prior to the separation of Great Britain. You got that was created by Thomas Jefferson, called Jefferson Manual. Then you got Paul's manual, which is a dealing with Mason's manual, Paul Mason's manual, and you got Robert's Rules of Order. That's the 3 rules governing the conduct, the legislature, and the privileges of those who occupy what we call the commissions of the Senate and the General Assembly. Let's read what Thomas Jefferson said real quick. Read that, Countess Middleton.
All right. Parliamentary Practice for the Use of the Senate of the United States by Thomas Jefferson.
Okay, let me go to where we need to go. Okay.
Section 1, the importance of adhering to rules. Mr. Onslow, the ablest among the speakers of the House of Commons, used to say.
Oh, I'm sorry. I'm sorry.
Mhm.
All right, go ahead.
Go ahead.
Go ahead.
Okay. The importance of adhering to rules. Mr. Onslow, the ablest among the speakers of the House of Commons, used to say it was a maxim he had often heard when he was a young man from old and experienced members that nothing tended more to throw power into the hands of administration and those who acted with the majority of the House of Commons than a neglect of or departure from the rules of proceeding, that these forms, as instituted by our ancestors, operated as a check and control on the actions of the majority, and that they were in many instances a shelter and protection to the minority against the attempt of power. So far, the maxim is certainly true and is founded in good sense, and is always in the power of the majority by their numbers to stop any improper measures proposed on the part of their opponents. The only weapons by which the minority can defend themselves against similar attempts from those in power are the forms and rules of proceeding, which have been adopted as they were found necessary from time to time, and become the law of the House by a strict adherence to which the weaker party can only be protected from those irregularities.
My screen's acting up. I apologize.
No worries.
All right, go ahead.
Okay.
1 second.
And whether these forms be in all cases the most rational or not is really not of so great importance. It is much more material that there should be a rule to go by than what the rule is, that there may be a uniformity of proceeding in business, not subject to the caprice of the speaker or the captiousness of the members. It is very material that order, decency, and regularity be preserved in a dignified public body.
Okay, now we're just saying that they had a hard time to select the Speaker of the House.
For the Republicans.
For the Republican. Right, since this had never been done since the Civil War. And they're talking about the Speaker of the House.
The same issue.
All right, same issue. Read the legislator.
Section 2, legislature. All legislative powers herein granted shall be vested in a Congress of the U.S., which shall consist of a Senate and House of Representatives. Constitution of the U.S., Article 1, Section 1. The senators and representatives shall receive a compensation for their services to be ascertained by law and paid out of the Treasury of the United States. U.S. Article 1, Section 6.
Now, they never said anything about Article 1, Section 5.
Right.
Because Article 1, Section 5 gives the authority for the Senate and the General Assembly to make rules. Everybody follow.
Follow.
They mentioned Article 1, Section 1 and Article 1, Section 6, but Thomas Jefferson said never said anything about Article 1, Section 5. Because that's the authority governing the actions of the executive branch of the officers to create laws governing the Congress, the Senate and General Assembly. These are called standing rules. We're reading right now Thomas Jefferson's standing rules for Congress that he implemented, because the one that were in place by John Adams and George Washington was not right. I'm not going to say it. He's going to tell you why it's not right. Go ahead.
The Congress, the people that's running everything in America. The Congress.
That's what you're asking me?
Is the Congress sitting in the seat of the law people? Do they the ones who legislate the laws into power or pass them?
They're supposed to, but right now the executive branch, through an administrative procedure that was introduced by the executive branch, legislative branch has agreed to it. New legislation do what we call law reform. So the law reform of the legislation created under administrative procedures is not the same as the legislation created by the Congress.
The corporations be writing laws too, or legislating.
Exactly right. That's what we're subject to now.
Thank you, King.
All right, now Thomas Jefferson is trying to check it, because we know that all the acts of the executive branch for the creation of administration was created through the executive branch. And they want to get the judiciary branch to uphold that. And we're reading now the judiciary branch in Marbury versus Madison wasn't trying to do that because the legislative branch said not to.
Okay.
Right here.
For the powers of Congress, see the following articles and sections of the Constitution of the U.S. U.S. 4789, that's Article 1, Article 2, 1, 2, Article 3, number 3, Article 4, 1, 3, 5, and all the amendments. Section 3, privileges. The privileges of the members of Parliament from small and obscure beginnings.
Stop. Okay. Now you notice Thomas Jefferson mentioned Parliament. Because standing rules, it just means parliamentary procedures. But what rule are parliamentary procedures? Because you got different aspects of parliamentary procedures. You got Robert's rule, you got Paul Mason's rule, and you got Thomas Jefferson's rule. Now, we know that if they were going based off our rule, then we won't have a problem. Am I right?
Right.
But we're not going based off our rule, because that's not the language of Congress. The language of Congress is what Thomas Jefferson is telling us now, based off his standing rule for Congress, who was sitting in quorum at that particular time. And that's the founding fathers, from George Washington to John Adams to Thomas Jefferson, because this is his manual. Now read what he said. Of the privileges of, we're not even talking about the legislative, executive, and judicial branch. We're talking about, we have a problem with the recording, Archbishop? Everything good with the recording, Archbishop? Archbishop. Okay, go ahead.
Section 3, privilege. The privileges of the members of Parliament from small and obscure beginnings have been advancing for centuries with a firm and never yielding pace. Claims seem to have been brought forward from time to time and repeated till some example of their admission enabled them to build law on that example. We can only therefore state the point of progression at which they now are. It is now acknowledged, first, that they are at all times exempted from question elsewhere for anything said in their own house. That during the time of privilege, 2, neither a member himself, his wife, or his servants, familiaris sui, for any matter of their own, may be arrested on mesne process in any civil suit. 3, nor be detained under execution, though levied before time of privilege. 4, nor impleaded, cited, or subpoenaed in any court. 5, nor summoned as a witness or juror. 6, nor may their lands or goods be distrained. 7, nor their persons assaulted or characters traduced.
All right.
And the period of time covered by privilege before and after the session, with practice of short prorogations under the connivance of the crown amounts in fact to a perpetual protection against the
Archbishop.
Yes, King. Yeah, my internet is on. I've been having internet issues all week.
Okay, all right, good looking. Continue, Countess,
Okay, from the top here.
on 7.
7, not their persons assaulted or characters traduced, and the period of time covered by privilege before and after the session with the practice of short prorogations under the connivance of the crown amounts in fact to a perpetual protection against the course of justice.
Thomas Jefferson said that all those who are sitting based off this rule are doing it based off the propagation under the connivance of the crown. What does it mean to connive? To scheme,
Right.
right? Of the propagation. Let's look at the word propagation first.
And who was sitting on the throne at this time?
There was nobody sitting on the throne now, because now these are the founding fathers running the show.
Right, the interregnum of the Commonwealth. But English,
The propagation means interregnum. And you see this word propagation, it's the definite, the synonymous word is interregnum. Now, Thomas Jefferson said, go ahead.
Apologies, I was just gonna read it.
Go ahead, Countess.
Prorogation in the Westminster system of government is the action of proroguing or interrupting a parliament or the discontinuance of meetings for a given period of time without a dissolution of parliament. The term is also used for the period of such a discontinuance between 2 legislative sessions of a legislative body.
Okay, now Thomas Jefferson said that in his manual. Propagation under the connivance of the crown. So when you say propagation, that's the same as interregnum. He's telling you that what Thomas Jefferson, what John Adams and George Washington did was contrary to the instructions given to them by Viscount Cornbury, because Viscount Cornbury was the one who created the judicial system here in North America. How we know that? Let's just go to another qualification. Read this. This is from the district court judge, Edward Kingsby. Supreme Court.
The Supreme Court of Judicature. Composition, Chief Justice and 8 Associate Justices. PL 1900, page 349, section.
That's public law. That's public
law 1900, page 349, section 1. But may be held by Chief Justice or any one associate. Terms. At least 3 stated terms are to be holden annually. Public Law 1900, page 349, section 2. They are now held at Trenton on the 3rd Tuesday of February and 1st Tuesdays of June and November, respectively. Special terms upon 2 days' notice may be called upon order of Chief Justice and any 2 associate justices. Public Law 1900, page 352, section 18. This court now has power not only to fix times for holding its own courts, but also that of the circuit, oyer and terminer, common pleas, court of sessions, and orphans courts. Public Law 1900, page 349, section 2.
Now stop.
Jurisdiction.
This is New Jersey. History dealing with courts and lawyers of New Jersey. And he's talking about the district court judge who sat underneath 6th president, talking about the courts of common pleas, the courts of oyers and terminers, the courts of session, and orphans court, called probate court. Those are courts deriving from what we call the King's Bench. Did y'all hear me?
Yes.
This is the King's Court right here in New Jersey under public law. Continue to read.
Jurisdiction. The jurisdiction of this court is twofold. Original. It has original cognizance of all actions and demands at common law, whether personal or mixed. In general, it possesses all the common law jurisdiction of the several courts of King's Bench, common pleas, and exchequer in England, unless we're specially restrained by the Constitution. See ordinances mentioned under origin.
Do y'all hear this? Do y'all hear this? This is the district court judge of New Jersey talking about the history of New Jersey and the origin of their courts. And he's talking about these courts goes back to the King's Bench. Continue to read.
It is fully possessed of the remedial writs which belong to Westminster, such as mandamus, prohibition, sire facias, the several writs of habeas corpus, quo warranto, certiorari, etc.
Stop. Now, these writs are filed in the district court, but a district court judge can get a writ filed on behalf of them on the Supreme Court. And we read in my here, the Supreme Court has jurisdiction to deal with writs, and they're not exercising that authority under the Judiciary Act because Chief Marshal said it was unconstitutional. So not only do the United States Supreme Court don't have the authority to exercise writs or prerogative writ, not only do the district court judges don't have the authority to issue writs, because if that was the case, William Marbury did it on his own. Now the New Jersey Supreme Court of New Jersey don't have authority to issue writs. Let's see why. Continue to read.
Every writ of dower and admeasurement of dower, but see 2 GS 1279, section 21, or pasture are to issue out of and be made returnable to this court or to the circuit court of the proper county. 2 GS 1277, section 9. Legacies may be sued for in this court. 2 GS 1938, section 1, and see also 2 GS 1940, section 15. Has power to remove trustees in certain cases.
Stop.
3.
Okay. We are trustees. They're not trustees of the King's Court. They're trustees of an administrative court, and the authority of and the job of administrator is to deal or manage a trust. So if they're not dealing with the King's trust, then guess trust who they're dealing with? Those created by that letter patent, that birth certificate. Under the so-called way they created, but we know the origin of the statute was already put in the trust by who? Henry VIII. And we know that that trust belongs to the church. According to Count Paulette versus Daniel Clark, or propagation of the gospel, because King George held in the trust since the Revolutionary War. Let's continue to read.
King, point of entry. May I ask you for that reference? May I ask you for that reference one more time?
The town of Paulette versus Daniel Clark. Just look up Sestuque on Wikipedia and go to case law, and it'll bring those two cases up. Right there on Wikipedia, Sestuque. It had nothing to do with an individual estate. So everybody thinking they got an individual trust set aside for yourself, you don't. The estate is a part of God's, because that is the law. The law is the one who creates the law. And according to the scriptures, God created the law. So if God created the law and left an inheritance for those who he call his children, then y'all got a question to ask yourself. What God is he talking about? Because our gods were to people who look just like us, talk like us, created like us, had the ability to write down the law. Continue to read, Countess.
Aliens may, okay.
One second. I gotta make this shorter. Oh, 1 second. Go.
Okay, the courts of New Jersey. The proceedings of certain inferior courts by certiorari was passed before the adoption of the Constitution of 1844. See effect of Public Law 1903, page 343 upon above. The Act of Constituting District Courts provides for an appeal to the Circuit Court, but this.
Hold on. You're talking about if you don't like the district court decision, you can go to a circuit court. Well, what the hell is a circuit court? If the district court don't have the authority, because the district court was appointed under the Judiciary Act. And now you're telling me the Judiciary Act don't have the authority to issue writ, nor did they have a decision in the final of appeal. Because it just said right here, you can go to the circuit court, and the circuit court were here under the King's Court. Because the circuit court was called a court of error in appeals. Continue to read.
But this, okay, the Act Constituting District Courts provides for an appeal to the Circuit Court, but this is nothing but a writ of certiorari in a new name, and the Supreme Court has declared it unconstitutional.
You hear it? You hear it? It's unconstitutional. The district court ain't got no authority whatsoever. Continue.
Okay, that's in Flanagan versus Plainfield. Continue. The Supreme Court accordingly has discretion as to whether costs will be allowed or not. And that's Smith and Company versus Hallshire, 52 ATL REP 308. The Constitution prohibits the removal of the proceedings of any orphan's court by means of the writ of certiorari, except in cases where the court has no jurisdiction. Origin. Lord Cornbury, the first royal governor, promulgated an ordinance in 1704, which among other things provided for a Supreme Court. In 1714, and at various times thereafter, ordinances relative to this court were promulgated until April 29th, 1723, which is in book AAA of the Commissions 184. When an ordinance was given the people, which to this day is the foundation of the several courts therein mentioned. As is noted under the head of origin in the Court of Common Pleas, other ordinances were passed after the one of April 29, 1723, but the changes made were principally in reference to the times and places of meeting. Attention is called to the ordinance of August 1st, 1751, recorded in Book AAA of the Commissions, number 1, page 313, and printed in 18 New Jersey Law Journal 202. The paragraph defining the jurisdiction of the Supreme Court is somewhat different from that contained in the ordinance of April 29, 1723. It reads, "We do hereby fully empower the said Supreme Court to have cognizance of, to hear, try, and determine all pleas, civil, criminal, and mixed, and all other actions and suits in law and equity as fully and amply to all intents and purposes whatsoever, as all or any of our courts of King's Bench, Common Pleas, or Exchequer, in that may be brought before it by agreement of council. That's Rule 76. The state is divided
No,
into
right here, you
nine.
missed right here.
Okay.
Right here, you missed that part.
Oh, here.
Exchequer in that part of Kingdom of Great Britain.
That part of the Kingdom of Great Britain called England have or of the right ought to have. Just at about this time, the people of New Jersey were very much set against the court.
Hold on, read that. Start from here. It says, we do hereby fully empower. Read that, start from there.
We do hereby fully empower the said Supreme Court to have cognizance of, to hear and try and determine all pleas, civil, criminal, and mixed, and all other actions and suits in law and equity as fully and amply, to all intents and purposes whatsoever, as all or any of our courts of King's Bench, Common Pleas, or Exchequer in that part of the Kingdom of Great Britain called England have or of the right ought to have.
Now, y'all hear this. This judge disqualified New Jersey being a part of England, now called Great Britain. He disqualified that for us, a district court judge. Continue to read.
Just at about this time, the people of New Jersey were very much set against Chancery. And only 5 years after this ordinance was promulgated, Smith, writing of New York, said that the wheels of the court rusted on their axles, and that its practice was condemned by all gentlemen of eminence in the profession. Was it the intention of the governor and council by this ordinance to give the Supreme Court the equity powers of the Court of Chancery?
Okay, let's go ahead. All right, what we got here? Read this. Read that form.
The King's Bench. The Court of King's Bench, formerly known as Court of the King before the King himself, was a court of common law in the English legal system, created in the late 12th to early 13th century from the King's Bench initially followed the monarch on his travels. The King's Bench finally joined the Court of Common Pleas and Exchequer of Pleas in Westminster Hall in 1318, making its last travels in 1421. The King's Bench was...
Go ahead, brother.
When they say the King's Bench finally joined the Court of Common Pleas, what did they mean by joined the Court of Common Pleas? Joined it.
Good. Okay, when the King's Bench was called the Exchequer of Pleas. The Exchequer of Pleas, as they said, was the king, which accompanied, was the council which accompanied the king everywhere he went in his travels. When the king was not there, they set what they call the Courts of Common Pleas. The Courts of Common Pleas deal with issues that deal with the people of the kingdom and problems they had against themselves when the king was away.
So
that's why you had what they call a world governor put in place.
So legally, this was okay?
Legally, it was okay, because when you spoke to the world governor, you spoke to the crown.
Got you.
But when they dissolved the crown, the governor abandoned ship. This was done under what we call the creation and appointment of a Supreme Court, because he was the last court of his law. Instead of him doing this job, he put a whole new Supreme Court in there to take away his responsibility. But they did it under the law through creating what they call an administrative government. And that comes through the history dealing with Alfred Driscoll and Richard Henry Lee, where the Supreme Court sits now in Trenton, New Jersey, under the Administrator Act, under Title 52, 14B1 of New Jersey by statute. This is an administrative act I created by statute contrary to the legislation. And nobody's going to know it because the origin of the legislation goes back to what? The standing rule created by Parliament, because those were the lawmakers.
Point of interest.
Go ahead, Sia.
Once they done away with Parliament, you ever heard this the phrase "no taxation without representation," brother?
Yes.
Yes, sir.
So without being legally recognized or represented in a body of politic via the Parliament, they done away with Parliament. So therefore, you had no way to get to the King's consciousness via the King's bench. So they were basically usurped or unilaterally usurping the control over the government by removing the common people access to the crown or to the legislator or to the king or to the government that rules him.
Well said. Well said. Read this for me, Brother Hobbs.
A prerogative court is a court through which the discretionary powers, privileges, and legal immunities reserved to the sovereign were exercised. Let us be clear, the sovereign is the king and the sovereign is the king's bench, should they be exercising his will as their judicial.
No. The sovereign is the crown.
The crown. And what is the crown?
The crown is sovereign. The
Definition.
king represents the crown. Well said.
Thank you, Elder. In England in the 17th century, a clash developed between these courts, representing the crown's authority and common law courts. Prerogative courts included the court of the executor, the court of chancery,
Exchequer.
as exchequer, the court of chancery, and the court of the Star Chamber. Their procedures were flexible and not limited by common law procedures. The Star Chamber became a tool of Charles I, employed against his enemies, and was abolished by Parliament. A parallel system of common law courts was grounded in Magna Carta and property rights. The main common law courts were the Court of the King's Bench and the Court of Common Pleas.
Hey, read, brother.
Let's get this law. The term also applied to one of the English provincial courts of Canterbury and York, having jurisdiction over the estates of deceased persons. They had, forgive me, King, this is dear to my heart because I've been dealing with my estate for years. And when you bring me to how should I say it? Sound mind and right judicial knowledge. It brings a sense of comfort in it, and it does some healing. So that's what I'm getting right now in the house.
Go ahead, brother.
They
heal yourself.
Yes, sir. They had jurisdiction to grant probate or administration where the diocesan courts could not entertain the case, owing to the deceased having died possessed of goods above a set value in each of 2 or more dioceses. The Prerogative Court of Canterbury was a church court under the authority of the Archbishop of Canterbury, which was responsible for the probate of wills and trials of testamentary causes where the value of the goods involved was greater than £5, and the property was held in 2 or more dioceses within Great Britain. While wills might also be proven at York, Canterbury's jurisdiction covered southern England, including London and Wales. Its archive also contained large numbers of wills relating to individuals who died abroad but owned property in Britain. In the period,
Stop right there. Okay. Now let's clear. Title 26 of the Magna Carta, Article 26. Everybody see that? Magna Carta 1215. Everybody see that?
Yes.
Okay. Let's go to article. Read the first article, first one for me. First one, article, right of the church. Read that for me, Brother Hobbs.
that the Church of Magna Carta 1215, Article 1, rights of the Church, that the Church of England shall be free and have her whole rights and her liberties inviolable, and we will have them so observed that it may appear that the freedom of elections, which is reckoned chief and indispensable to the English Church, and which we grant and confirm by our charter, and obtain the confirmation of the same from our Lord and Pope Innocent III, before the discord between us and our barons was granted of mere free will, which charter we shall observe, and we do will it to be faithfully observed by our heirs forever.
Okay, now before we go on, Brother Burgess, being that you got the last name Burgess, all right, it's a text for you, Noble. Teach your students, teach your people. All right, well, how do we get in this problem that those who sat in quorum were from the House of Burgess? Now we know that the House of Lords and the King's Council were dissolved and put under the Commonwealth as a result of the interregnum as stopping the demise of the crown. Who was this individual that sat in the House of Burgess that made their way into our assembly as free men? Who is that individual?
Simon DeMarthy's.
Tell them who that brother is.
A rebel baron.
A rebel baron. That's my man. A rebel baron who went against Henry III. Henry III was descendants of the Plantagenets, and this is how the Burghers or the House of Burghers got into our assembly through this guy, Montfort. Well said, Brother Burgers. You listening, though? All right. So let's go here. In closing, 26, Article 26. Read this, Brother Hobbs.
Article 26. If anyone holding of us a lay fee die, and the sheriff or our bailiffs show our letter patents of summons for debt, which the dead man did owe to us, it shall be lawful for the sheriff or our bailiff to attach and register the chattels of the dead found upon his lay fee to the amount of the debt by the view of lawful men, so as nothing be removed until our whole clear debt be paid, and the rest shall be left to the executors to fulfill the testament of the dead. And if there be nothing due from him to us, all the chattels shall go to the use of the dead, saving to his wife and children their reasonable shares.
Read 27, and then read 26 and 27 all over again. Read 27, and then read 26 and 27 all over again.
If any free man shall die intestate, his chattel shall be distributed by the hands of his nearest relations and friends, by view of the church, saving to everyone his debts which the deceased owed to him. 26 and 27 in succession. If anyone holding of us a lay fee die, and the sheriff or our bailiff show our letter patent of summons for debt which the dead man did owe to us, it shall be lawful for the sheriff or bailiff to attach and register the chattels of the dead found upon his lay fee to the amount of the debt by the view of lawful men, so as nothing be removed until our whole clear debt be paid. And the rest shall be left to the executors to fulfill the testament of the dead. And if there be nothing due from him to us, all the chattels shall go to the use of the dead, save to his wife and children their reasonable shares. If any free man shall die intestate, his chattels shall be distributed by the hands of his nearest relations and friends by view of the church, saving to everyone his debts which the deceased owed to him.
Well said. Okay. Very important.
Ventures.
Go ahead,
Oh.
CA.
He said in view of the church, not in view of the government, not in view of the corporation, in view of the church. Peace. That's it.
Key word, lay fee. Let's find out what this word lay fee means.
Is intestate without a will, King?
No, not exactly.
Okay.
Let's get a legal definition. All right, what it says. Okay, read that for me. Can you see that? Hold on. Let me close this out. Late fee. Let me just type it in here. And this will be in closing. Okay. Everybody see that?
Yes.
All right, read that, Countess Middleton.
Lay fee. A fee in land held on condition of the rendering of secular as opposed to religious services.
Read it again.
Lay fee. A fee in land held on condition of the rendering of secular as opposed to religious services.
Okay, when you say secular, secular is a polity without religion. That's called separation of church and state. That's called lay fee or fee simple. So if a lay fee is a tenure that's secular, then the only thing opposite of secular is a religious polity called a church state. And before they broke away from the colonies under secular law, they were called a church state, i.e. the Church of England. And with that, I digress. Woo! All right. So with that, once again, it's very important to understand as members of this polity, your position as being up here on this panel. Because wherever the kings go, his king's bench go. You know what I'm saying? And we can't even deal with the courts of the common pleas till we deal with the courts of the courts of exchequer. The courts of exchequer with those who owe a debt to the king. Now they took the debt that owed to the king and put the debt on us. And every time they hold us into these courts by bills of attainders, we're paying the debt for them because there's never some type of evidentiary fact in regards to the claim itself. It's always based off some plea. And a plea is nothing more than a contract by way of force, by way of promise, or by way of injury. Because they say, if you don't plead, we're going to lock you up anyhow. You don't plead, we're going to give you this money, you're going to post this bail, or we're going to throw you away for life. That's how they scare you. These are all violations of law. So with that, I leave you in the hands of the Queen, and then Archbishop follow through, and he'll let everybody give their dissertation in regards to the understanding and the articulation and the overstanding of this lesson. With that, I digress.
Beautifully said by the King. I just want to say study. Until we learn these lessons, we're going to be continuously railroaded by these so-called officials. With that, I digress.
Well said, King. Archbishop, you got the floor, and you allow each one who digressed after you to take their part. Do the women first. First, you give your dissertation, then start with the women, and then start the brothers.
Once again, everyone, this was a great lesson prepared by King Clifford Jefferson, as well with the assistance of Queen Godwin. Like she said, you must study these lessons accordingly, especially if you know on the birth certificate, it's a settlement certificate which ties you to some form of indenture or debt that has to be paid. And until that is paid, they're going to continue to keep treating you as chattel property or ward property of the state until you actually pay the debt, which is actually getting your consciousness to tie you back to the Kingdom of England, which you actually have your family hereditaments tied to an estate that you actually keep claiming that you are part of, but you can't be part of anything that you're actually not doing the requisites that required for you to be actually partake into it. So once you understand those overtones, then that'll give you the ability to start putting yourself in the proper position. So therefore, like the Queen said, you're not getting railroaded by these imposters out here. So with that being said, I digress, and I leave the floor for
You
the
said
rest of
that. Let me just speak on that, Archbishop. Very important that you said that, because a lot of people are watching our videos and they're professing to be descendants of us as heirs. You can't be an heir and a descendant if you don't know this information. There's no way possible. You cannot mimic this. If you mimic this, that's what we call law reform. You're changing the law by reforming the law in a language other than the way it was written. So you can talk this all day long. The key is being who you say you are. That's where the test comes in. So well said, Archbishop. You got the floor.
All right, I digress, and we leave the floor for the rest of the panel for the closing.
All right, Countess Middleton.
Yes, King, I really appreciate this class. It really clarifies, and you know, the importance of a glossary and the importance of right definition. And of course, I appreciate how you pull it all together, clarifying the letters patent, clarifying how we have to assert our rights. And again, for me, it's just right definition. And I digress.
Right. You're right. The definition defines what it is, its purpose. Remember, we gave names to everything. You got a noun, a person, a place, or a thing. The most important thing about that noun is the person, because the person gives name to the place or a thing. And who, as Archbishop says, whoever names it, claims it. So if you allow them to rename your history, your law, your custom, then they have the right to have it. Well said, Countess Middleton. Let's have speak.
Say that again.
Countess Walker. Is Countess Allen able to speak, or any of the other sisters?
Countess Harris, she's gone. She's doing her treatment. I don't know if Countess Allen is still available or not.
Okay. Until they show their face, we're gonna move forward. Brother Hobbs, you got next.
I'm just grateful to be in the house, King.
Thank you, Noble. Thank you. Tell me a little bit about the lesson. What did you learn from the lesson?
Venue is a very strong position to understand the proper venue when it comes to making your claim. And, you know, being in the right house puts you in the right position to have it authorized by the right person. Sure.
Oh, authorization, and that's the law. If the authorization is the law, and the law is created by the lawmaker, then you either got a physical person or an abstract one, right? Because you can't see God, and God ain't got no fingers. God ain't got no mouth. For somebody who ain't physical. So that means that your next stop, if there ain't gonna be a next stop, is somebody you don't know, that you can't see, and that you can't talk to. That's gonna be a lonely situation for you. When we speak, we're communicating with our ancestors, even though they're on the astral plane. We're still communicating with them. We're still becoming who we were here on this plane and on the astral plane, because our mind's not even attached to our body. Our brain is attached to the body, but our minds is not. Anything that the mind does, the body will follow. As above, so below. Your mind is above, but it ain't even attached to you. So you're starting the ascension what we call transformation, or in this case, we call incarnation. It's called the resurrection of the dead. We use resurrection of the dead through incarnation of our spiritual body, i.e. our mental body. And the contract world, they call that incorporation. So you have to incorporate into the church that's intangible. And the property is intangible until you see it, the intangibleness that can't be touched. If the intangibleness of the property can't be touched, then nobody can take it from you. And that's willed in the law. All right, so we'll go to Brother C.A. Murphy from the House of Murphy.
Peace and love, everyone. What a great lesson. What a great visiting of our older lessons. What a what a great time to be alive. King, obviously this is another reassurance and reformation of our energy and information. The ability to place yourself under your own vine and fig tree, under your own house, it is yours to claim only through your awareness, consciousness. They have laws, procedures, exchequer, to deal with debts, deal with criminals, orphans. Everything was set up by our ancestors to handle and administrate this plane of manifest. Okay, so our ancestors were highly intelligent. They were aware of the minority sense or want of power. They were aware of land incursion, and all of these laws were set in place so that the heirs would not only keep their law intact, but to acknowledge them in perpetuity. So this lesson qualifies the research, the legislation, the statutes that have been in existence since time immemorial. We are aware of the belligerent trustees who have attempted in different times to reform or do away with our hereditaments or the law that precedes them, not following the standing rule, not keeping their oaths, not following rules of procedure. However, as heirs, it is our duty, being of the King's consciousness, of the King's bench, to not only be the light for all of the brothers and sisters to see, but to speak the light and to know the light and to be with the King. So it's just a marvelous time to be alive. I'm so grateful for this lesson. I'm so grateful for my countesses, for my nobles, and for my king and my queen. And all of you at the sound of my voice who are viewing this video, we just ask you to do your due diligence, do your study. Don't try to put the cart before the horse. Don't try to usurp or unilaterally take that which is not what's not yours. It's only through your true acknowledgement of the original church and its hereditaments, safekeeping of the lands and its people, that you can find yourself back home. And our King has incarnated and personified that station. So you are welcome to come into this forum, but it's only through your consciousness and study to show yourself approved. So with that being said, I digress. I love you all at the sound of my voice, and I trust that in all you're getting, you'll get overstanding of your heritage, your hereditaments, and your heirship in lieu of abstract title for this land. So peace and love, and let's look forward to our next lesson and continue to review our lessons that we have received. Peace.
Well said, C.A., and I like the fact that you ended with the standing vote, because the fact that Thomas Jefferson bear witness to the propagation of the connivance of the crown, even having the surname coats of arms Jefferson, shows you that he was protecting the estate. So big ups to your Thomas Jefferson. All right, Brother Esquire Burgess from the House of Burgess. Greetings, no.
Greetings, family. Can y'all hear me?
Yes, sir.
Well, I appreciate everyone up here as well as everyone watching. It gives me fire to continue to do what I do. I show my love to y'all by the actions that I do within this church. But in regards to the lesson, I feel like I will have to say this to y'all to go check out the video House of Planchonette by Dan Jones. Even though King already qualified it, but that video goes into Simon DeMarco and came up to this point right now where we at underneath these immigrants, right? And another thing I want to share is if we truly allodial heirs and successors of the crown, we wouldn't need this right here. And when
There you go.
And when I pay attention to my document, it have registered signatures on it. It has a seal that was sanctioned by Charles II. And then I look into the statutes that give them the authority to say what I am. And then I pay attention to how they infringing on where we exist. So how can y'all exist if I exist? And that's what I understand. So I plug my life into the lessons of what King say, from utility bill, that's a letter patent to me, to a license, to quick card. I can't get a passport or anything unless I have this document right here. For me to understand that is let me know how to move within this movement. So that's what I share to y'all as my peers.
There you go. That's the best way to navigate. Well said.
What's the name of that video, Brother Burgess?
Dan Jones by House of Planchonette by Dan Jones. It goes from Time Immemorial all the way up to the House of Tudor, and then it goes right into the War of Roses, and it calls everybody out by name.
Yes, sir. And then you'll see what Magna Carta was created on the purpose for the Magna Carta. Because old barons, that's the ones who sitting up in your Senate and General Assembly today, called the House of Burgess, with nothing more than a Virginia company operating under the British Crown, which is not the same as the English Crown. So well said, Brother Burgess from the House of Burgess. Next, we have Brother Means from the House of Means. Greeting, though. Is he still with us? Brother Means?
No, I think Brother Means is gone.
Okay. Brother Gray from the House of Gray.
I know Brother Gray is at work, so I don't know if he's going to be able to chime in.
I'm
he's
here, Archbishop. Thank you. Yeah, I'm at work, so I'll be fast. Really enjoyed the lesson. To camelback on what CA said. I looked at my birth certificate as well, and it had those 2 dates, and I had never seen that before because I really didn't pay attention. And that second date is when they made us a pretty much a legal fiction or a straw man at that date. And someone else is using that estate for their own good. Until I prove myself alive, like it said there, the only way we are going to get remedy is to be able to claim that you are alive. And at that point, you can stand up and be heard, because a dead man can't speak, a dead man cannot fight, a dead man can't protect himself. Only a live, living man and breathing man can protect himself. So this is the first order that we must do in order to gain our estate back.
And you gotta have blood running through you.
And the blood. Yes.
You gotta have that royal blood running through you.
Yes, sir.
Not just any blood, but that royal blood.
That free certificate given by a monarch.
Yes, sir. All right, we have Brother Countess Harry, Brother Cordell. Brother Scott. Did I get Brother Scott yet? Greetings, Brother Scott from the House of Scott, my noble brother.
Can everybody hear me on the panel?
Yes, sir. He be ready, boy.
Is mine up? Okay, there we go. Sorry about that.
All right.
King, this lesson is very important. There's very few people that don't have a birth certificate. And this is to include our deceased elders. Those birth certificates are gonna have to be accounted for at some point. Archbishop Murphy went over some things. This is when I first came into the church when we were talking about these birth certificates. And he made the comment that with the information, King, my little one's all over me. That's what I'm trying to. I don't know how she got in. Can you hear me, King?
Yes, sir. I can
All
hear
right,
you.
sir. Sorry about that. For the little.
It's all good. No, we
Interruption.
love the children.
Again, King, I wanted to read something. Let me find it right here. When you went into Bill of Attainder, it really came full circle for me. And this is a definition that I just found here on Google. And it says a Bill of Attainder is an act of a legislature declaring a person or a group of people guilty of some crime and punishing them, often without a trial. As with attainder resulting from the normal judicial process, the effect of such a bill is to nullify the targeted person's civil rights, most notably the right to own property, the right to a title of nobility, and in at least the original usage, the right to life itself. In the history of England, the word attainder refers to people who were declared attained, meaning their civil rights were nullified. They could no longer own property or pass property to their family by will or testament. Attained people would normally be punished by judicial execution, with the property left behind escheated to the crown or lord rather than being inherited by family. And that seems to be exactly what the birth certificate is doing to us. I digress.
Well said. And that takes us back to what we call a writ of attaint. A writ of attaint, based off the common law, is a writ from a minor to bring those who rendered an order that was a writ of error and punish those who gave that writ of error, where it was done by a jury or any other person. If you gave an order that's invalid, then the same encumbrances that defrauded that person in lieu of that error, you suffer the same penalties and even more. Know what I'm saying? So well said, brother. So
hey, point of interest, just to come back real quick, Queen and King. And your estate, whether the person transitions, dies or not, the estate still has value. And who's administering the value of that estate is what's in question. I yield.
Yeah, well said. Well said. Brother Millicent from the House of Millicent, greetings, Ross. Are you there with us? Okay, so with that, I think everyone spoke from those prospective houses in regards to, did I miss anyone?
Was Brother Harris on?
Brother Harris, did I get you, Brother Harris?
Brother Harrison, speak.
Yeah, go ahead, Brother Harris. You got the floor. Is you there? I don't see him. There lurking before we close out. Anybody got any questions? So your homework lesson for next Sunday is
He said we're not having class, so.
yeah, we are.
Okay.
Our Bishop might not be there, but I'm going to be able to have class. So your next homework will be not the next two videos after this one, but the one after that. Not the next two videos after this one, but the next video after the last two. All right, everybody understands?
That's the fourth video to the last.
That's the fourth video. And it's called, let's see. It is so it's called Relation of Heirs Presumptive. It's called Revelation of Heirs Presumptive. Revelations of Heirs Presumptive. That's the fourth video from the last. That's your homework. I expect to have the same dialogue we had today. Everybody did a good job with articulation of the homework that was given to you. I look forward to your growth in the next. Thank you for joining us, Brother Hobbs from the House of Hobbs, by way of the assistance of Council Middleton from the House of Middleton, as well as everyone else from their respective houses, members, officers, staff. We love you, and we greet you in the name of our forefathers that were in the past and is in sure to come. And with that, we greet you as we meet you in peace and love. And with that, we say
Peace, family.
peace. Talk to you soon.